Good morning, Mr. Chair and members of the committee. My name is Blaine Conzatti. I serve as president of Idaho Family Policy Center. RS 32021C1 deals with indecent sexual exhibitions in public or other places where children might be present. It simply creates a duty of care for facilities, for hosts and organizers of indecent sexual exhibitions to take reasonable steps to restrict children's access to indecent sexual exhibitions. Please note, I think this is important, the RS does not ban sexual exhibitions outright. Instead, it functions as a constitutionally permissible time, place, and manner regulation, protecting children while still allowing adults to attend indecent sexual exhibitions if they choose. The Supreme Court has regularly upheld time, place, and manner regulations if they're content neutral and if they do not limit alternative avenues of communication. In this case, obviously, we're still allowing these performances to take place in private, or if the organizers simply check IDs at the door. That's all we're asking, just reasonable steps like checking IDs at the door. I also want to note really quickly what types of performances we're talking about. So what types of performances fall under the scope of this proposed legislation. The indecency standard that we're using here mirrors the same standard that the FCC has used for decades now to regulate daytime television broadcasts. So if it's appropriate for daytime television broadcasts, then it's appropriate for a live performance in public where children might be present. It's as simple as that. We're not talking about gender-bending performances in Shakespearean theater, right? Those are regularly seen on TV. We're not talking about cheerleading performances. We're not talking about the movie Mrs. Doubtfire that was really popular when I was a kid. All these things are regularly seen on daytime television broadcasts, and the federal government and local communities have allowed that. It's also important to note just really quickly that this proposed legislation would not target any specific type of sexual exhibition. It applies equally to all indecent sexual exhibitions, whether drag shows, erotic dancing, burlesque performances, strip teases, etc. So all we're saying, again, shouldn't take place in a public park or other place where kids are present. And the RS is narrowly tailored to promote the state of Idaho's interest in protecting kids from those indecent sexual exhibitions. And with that, Mr. Chairman, I'd ask that you guys introduce this RS, and I'm happy to stand for any questions you might have.
Thank you, Mr. Conzatti. Are there questions for Mr. Conzatti? Representative Mickelson.
Yes, Mr. Chairman, Mr. Conzatti. I guess I have a question. When I read on the first and second, and third pages, it seems like it's all a bunch of background, and it's really not about what we're actually doing. I don't think we actually get to what you're trying to accomplish until I think you get to page 3, line about 19. So I guess my question is, why are we putting court cases into Idaho code, referring to them, versus just having statute that lines out what is acceptable and what is not?
Mr. Conzatti.
Yeah, Mr. Chairman and Representative Mickelson, thank you for asking the question. So it's common in legislative findings to provide a legal rationale for the legislation and to indicate what the legislature's intent is in passing the legislation. So what we're doing in those legislative findings is we're explaining the legal basis for this proposed legislation and explaining why it's defensible under current case law.
Representative Shubin.
Thank you, Mr. Chairman. Mr. Conzatti, I'm all for protecting children. I recognize that children shouldn't be exposed to sexual explicit material. They can't process it, it's not good for them, etc. But what I see in the defense section for the civil action, I don't see...
Representative, could you give us a page number and maybe a line number so we can follow along with you?
Page 4,
Okay.
starting line 3 through... all the way down. I don't see any defense for the host to just announce that there might be sexually explicit material to protect themselves. I'm just thinking of the example of, let's say there's an improv comedy show and you can't control what the people who show up will do, and then you're liable.
Mr. Conzatti.
Yeah, Mr. Chairman and Representative Shubin. So if you take a look at paragraph E, subparagraph 1, So we do have an affirmative defense if the host is able to produce a legally enforceable contract signed by the event organizers, performers, or authorized agent working on behalf of the event organizers or performers when such contract stipulates that the performers at the event shall not engage in an exhibition, show, or performance that violates the requirements of subsection 1. So if the host, if the facilities are able to produce a contract that prevents the performers from engaging in indecent sexual conduct, then that would be an affirmative defense that excuses their liability. Even if they don't have that contract, the plaintiff would still bear the burden of proving that the host failed to take reasonable steps, which is a high bar to reach. So, we're just utilizing the normal principles from tort law here. The host, all the normal principles of tort law would still apply.
Follow up?
Yes, thank you, Mr. Chairman. Wouldn't it be more simple to just have the host announce that there might be explicit material so the parents don't take the children or the adult doesn't bring in the minor, and that way you just don't expose the child altogether? Isn't that more simple and easy and less burdensome?
Mr. Conzatti?
Yeah, Mr. Chairman and Representative Shubin, we don't believe that children should ever be exposed to indecent content or behavior. And so we have a bunch of affirmative defenses in here to ensure that, institutions or entities are not being held liable for actions that they are not responsible for. All we're asking is that they take reasonable steps to prevent children's access. Reasonable does not mean burdensome, and there's good case law on this as well that we can get into, I would imagine, during the full committee hearing if the chairman wants. But all we're asking is that these entities take reasonable steps to restrict children's access.
Follow up? Okay, you're good. Representative Skog?
Thank you, Mr. Chairman. As to Representative Shubin's question about affirmative defense, that doesn't limit the defenses that a defendant can bring up. That just mentions those are an affirmative defense. So they could bring up defenses. I didn't know this improv was a pervert going to do these things. So, and then also I move to introduce RS 32021C1.
Committee, we have a motion to introduce RS 32021C1. Is there discussion on that motion? Or any further questions for Mr. Conzatti? Representative Achilles?
Just a comment on the motion, Mr.
Certainly.
I think on first read here, this appears to be narrowly defined, but we are, as others have acknowledged, adding 5 pages of new code and 3 pages of legal background. Do we really need to do that, or is there a more efficient way, number one? Number two, we're delving into a bunch of First Amendment issues here, and I just want to make sure we approach this very carefully. And 3, the affirmative defense section, it does feel insufficient, and I think maybe we can strengthen that to provide some more appropriate protections, but look forward to having that discussion when this comes back. Okay. Thank you, Mr. Chairman.
Thank you. Further discussion on the motion? Committee, the motion is to introduce RS 32021C1. All in favor signify by saying aye. Aye. Opposed, nay. The motion is carried. It will be done.